You heard it here first last night. There was frustration from one victim's father that gag or no gag, hundreds of court filings packed with vital information are still sealed. The gag order was lifted, but the docs are still sealed, probably for months. Steve Goncalves, father of Kaylee Goncalves, wants all of the documents released now so that he and his family and the other victims know exactly how to write their victim impact statements before next Wednesday. Here's what Steve told Ashley last night.
I know her sisters wanted to do a victim statement and address the exacts some of the things that happened to her, and they basically wouldn't share any information with us on what happened to her.
So what's going on? Well, there's a couple things going on at the sentencing hearing that's about to happen very shortly. The victims' families are being told to address the court, not Bryan Kohberger, the actual person who confessed to the horrible crimes. But the court also decided at a motions hearing to lift the gag order. He agreed to it, but it wouldn't happen before the sentencing hearing. The court would have to go through all the sealed documents and redact information that cannot be public. So you can read about that decision that the court made on my community post page. If we backtrack a bit to the change of plea hearing, the prosecutor did outline what evidence they had against the perpetrator. So the victims do have what happened. They just don't have the details that were sealed. Now, is this a hindrance for writing an impact statement? To answer this, let's talk about what is the purpose of an impact statement, referred to as victim personal statements over here in the UK. By making a statement, this will enable victims impacted by crimes to be part of the criminal process, being able to explain the impact of the crime in their own words, and it can be empowering and therapeutic for the victims of crime. However, it can also be very stressful. So it is not for everyone, but it really does help the criminal justice agencies to gain an understanding of the human impact of the offense. And hearing directly from a victim impacted by a crime can make the crime more real, and the offender may be encouraged to take responsibility. So in my view, it is important the offender hears about the implications of their actions. And this will have a powerful impact in restorative justice. Hearing how the horrific crime has impacted the victims and their families and others can influence the sentencing by helping the judge determine the appropriate punishment. While statements do not dictate the sentence, they can support the argument for harsher sentences or more lenient penalties. I can understand the frustration on the restrictions and not knowing the details, especially when you're supposed to address the conduct of the defendant, and how it appears by not having those details that are sealed, it gives the appearance that the defendant's rights are more important than the actual victims. Reading the court guidance, it can be counterproductive not knowing these details. So the guidance doesn't seem to make a lot of sense, but the focus is on you. You are the voice for your loved one, advocating for their character, how they, for example, enjoyed life, worked hard to achieve their goals, loved to share their fun times. The statement is part about them. The other part is about how the defendant's conduct affected you. For example, in this case, not knowing the details, the motive, and how that has affected you in the day-to-day. The other part of the statement is about the day-to-day, as just mentioned, but it's the cost of all this loss for you. For example, lack of concentration at work, lack of sleep, nightmares. Life feels lost, fear. And in the UK, the Ministry of Justice has an online leaflet about making victim personal statements. And look here, they are almost identical. The victims may not always have the details. This is because when there are changes in pleas, the justice process can move quickly. Oh, and interestingly, in the UK guidance, they address this exact point. What happens when the case progresses through the court and it may not be possible to attend court to read your statement. And they say the court is unlikely to adjourn solely to allow the person making the victim personal statement to attend. Remember, this happened very quickly as well in the case against Bryan Kohberger. He changed his plea, and the families had very little notice. So the other frustrating decision the judge made was to not, make the defendant Kohberger confess to where he put the knife, to do some form of allocution before he accepted his plea deal. So the American Bar Association has a document on what is an allocution statement. And after pleading guilty, the defendant is typically offered a formal opportunity to address the court, to express remorse and explain personal circumstances that might be considered in sentencing. Well, why would this happen when there's already a deal? This is known as an allocution statement, okay? These statements have a long and important history in the American legal system. So they serve as a variety of functions. The allocution statement provides an opportunity for the defendant to accept responsibility, humanize themselves, and to mitigate their sentence to ensure that their punishment is appropriate for both the crime and the person who committed it. So why would he do that now when it's pretty much already a sealed deal because the court agreed? But the court did say they could, go lesser, I guess. You can see my video that I did. I'll leave it at the end of this video if you want to watch it. See what my take was on, maybe what the court could do. But from the court's perspective, judges cannot simply accept a defendant's guilty plea. They must determine that there is an adequate factual basis to support the charge and the plea. And the plea was knowingly, voluntarily, and intelligently made. Allocution statements aid in making these determinations. With this in mind, not all defendants exercise their right to submit an allocution statement directly to the court. Lawyers may submit statements on the defendant's behalf, or statements may be waived entirely. Yeah, so I'll let you read that. I'll leave a link below, and have a read of that if you want to know more. But it doesn't look like we're going to get one from Kohberger, and this is frustrating. And look who else is weighing in. The U.S. President, Donald Trump, hopes the judge will make Kohberger, at a minimum, explain why he did these horrific crimes. If you want to hear all of what President Trump wrote, go to News Nation. I have left a clickable link in the top right of this video as they discuss, will this influence the judge? What's your thoughts? By leaving a comment, you may help someone else that will read your comment. And of course, I love to read all comments as they are valued, and together we can be more informed. And this information may help you or someone you know. In the meantime, on this channel, you'll find a variety of playlists to suit every curiosity about the justice system. And we provide you with a visual to information and the process. Going through a legal worry is devastating, and the Who Knew and Why Me playlists are designed to help you or someone you know. So please like this video if you like this kind of content. Hit the subscribe button and the notification bell if you want to be notified when I'm going live or upload another video. I'm Karen Cole from Legal Minded Friends. Information is power, meaning if you know something, you can make decisions that are right for you.